Good evening. We are team number 2. Orangeli, Winker, Carmen, and Sandra. And we are going to tell about the international criminal law and the responsibility of the individual in the international law. International criminal law is the body of public international law that establishes individual criminal responsibility for international crime, such as war crimes, crimes against humanity, genocide, and aggression. The exact definition of an international crime remains divided, but it is normally understood and violate fundamental interests of the international community and intellect individual crime responsibility. The generally accepted core international crime are war crime, crime against humanity, genocide, and aggression. Depending of the concept of international crime used, other criminalized conduct such as pirates or torture might also be considered an international crime. Many violations of international humanitarian law are nowadays considered war crimes. Crime prosecution for war crimes are meant to implement international humanitarian law. However, international humanitarian law is broader than the concept of war crime. Not every violation of international humanitarian law constitutes a war crime. The core system of international criminal law works through international ad-hoc tribunals, mixes of hybrid tribunals, and in the International Criminal Law Court as well as national court. One of the legal consequences of framing an act as an international crime is that it may give rise to what calling universal jurisdiction. Pursuant to the principle of universal jurisdiction, any state is allowed to try alleged perpetrator of international crime, even in the absence of any link between the accused and the state in exercise jurisdiction.
Where to find international criminal law? The genesis of international criminal law as a branch of international law can be traced back to the London Charter of the International Military Tribunal adopted in 1945. Since then, and especially over the past 2 decades with the proliferation of various ad hoc tribunals and the establishment of international criminal court, international criminal law has developed considerably. The statutes of international tribunal are the main treaties that are used by international criminal courts as a legal basis and guidelines for their activities. Most importantly, the Statute of the International Criminal Court. Other treaties include international instruments directly criminalizing certain types of conduct, such as the Convention on the Prevention and Punishment of the Crime of Genocide, and conventions which may be taken into account for the identification of customary criminal rules. The 1949 Geneva Convention with their additional protocol may serve both purposes. Customary international law may fill in the gaps where treaties don't contain explicit criminal norms. Such norms can be inferred from the jurisprudence of both international and domestic tribunals.
What are war crimes? War crimes are serious violations of international humanitarian law that entails individual criminal responsibility. War crimes can only be committed during times of armed conflict. either international or not international, as understood under international humanitarian law. While it is necessary that the crime in question was committed during an armed conflict, it is in itself not sufficient. The crime must be sufficiently linked to an armed conflict. This so-called nexus requirement is satisfied if the armed conflict plays a substantial role in the perpetrator's decision to commit the crime, his or her ability to commit it, or the manner in which the crime was committed. In order to define an act as a war crime, this act must, besides having nexus to an armed conflict, be a serious violation of international humanitarian law and entail individual criminal responsibility. During international armed conflicts, the Geneva Convention of 1949 and the Additional Protocol of 1977 criminalize a certain number of acts as grave breaches and oblige state parties to prosecute individuals responsible for such acts. Thus, the grave breaches automatically qualify for both criteria of seriousness and criminalization. Acts that are not defined as grave breaches must be examined on a case-by-case basis. For the International Criminal Tribunal for the former Yugoslavia, a violation is serious enough if it constitutes a breach of a rule protecting important values and involves great consequences for the victim.
What is the International Criminal Court? The International Criminal Court is a permanent international court established by the 1988 Rome Statute to investigate, prosecute, and try alleged perpetrators of war crimes, crimes against humanity, genocide, and the crime of aggression. To date, more than 120 countries have ratified the statute, in addition to certain of the crimes that fall within the jurisdiction of the court. The statute provides for the conditions under which the court may exercise jurisdiction. It may exercise jurisdiction over crimes committed by nationals of state parties or in the territory of the state party since the date of entry into force of the Rome Statute for the state parties in question. In addition, the United Nations Security Council can refer a situation to the International Criminal Court, triggering its jurisdiction and extending into countries that may not be parties to the 1988 Rome Statute.